Welcome to Legally Speaking with attorney Antoinette Osbourne. This program is for information purposes only. If you need legal advice, you can contact me, Antoinette Osbourne, at 718 502 9137. That's 718 502 9137. The office focuses on immigration, divorce, bankruptcy, real estate, and estate matters. Now, today I wanted to focus on work permits in terms of how is it that you are eligible for a work permit, the ramifications of working in the United States without legal authorization. So the program is for information purposes only. If you need legal advice, you can contact the office at 718 502 9137. That's 718 502 9137. So, what are the penalties for working without authorization, and if this is discovered in your application? Employers are not authorized to employ someone unless they have the legal ability to work. And this often is indicated by the documents that you provide. And for employers, they are required to complete what is known as an I-9. Now, on this I-9 form, you check off how is it that you are authorized to work. For anyone who is a green card holder, or if it is that you have legal authorization to work, or God forbid, you're signing this form and you don't have legal authorization to work, you should not check off citizen. This will act as a false claim to citizenship. It will bar you in all future applications. So let's say that you had a work permit and you went ahead and you checked off that you are a US citizen. If you later, and this is for representation after September 30th, 1996, if you went ahead and you checked US citizen, what this does is to permanently block you from ever getting a green card. And for the green card holder who is seeking citizenship, if this is ever discovered, this permanently blocks you from citizenship and now you become deportable. So you have to be very careful when filling out forms. And when you have a social security number, if you're doing applications, watch out for this. And you should also watch out for this when you are applying for your driver's license. There's a section on that form that registers you to vote. By registering to vote, you are claiming to be a US citizen, and you have to be very careful where you're seeking to register to vote unless you don't need to be a citizen to vote in that specific whatever election is happening. But for federal elections, certain elections, you are affirming that you are a US citizen. So you have to be very careful when you are in fact completing these forms. Good morning, Renee. Good morning, Madge. So I'm going to urge you, if you are filling out a form, you are not a US citizen, on these I-9s, you have the option to check whether you are a lawful permanent resident, whether you are a US national, whether you are a US citizen, or whether you have legal authorization to work. If you are an immigrant, you are not supposed to be checking off US citizen. Be very careful with these I-9 forms, because certain field offices, once they become aware, especially when you've had a social security number before and they become aware that you have worked, they will send to the employer to request that I-9. What that does is they have the verification on the document where you in fact actually claimed to be a US citizen. So if it is that you are looking to apply for an adjustment of status or a green card, probably you went outside the country, you worked on a visit, and they become aware of this and you had checked off you are a US citizen, that permanently blocks your green card. If you are a green card holder and you check this off, you now become deportable. So I just want to encourage you, when you are filling out these forms, just be very, very careful what elections concerning your status that you are in fact checking off, right? Now, this I-9, employers are required to keep this. I think it's for a period of up to 3 years. Some and with scanning documents now, gone are the days of physical documents. Some employers do in fact destroy the documents after a few years, some do not. And you'd be surprised where you have case law where an employer kept the I-9 for over 20 years. So when immigration requested a copy of the I-9 and they were able to determine that this person had checked off citizen, then unfortunately it blocked that person from getting the green card, made that person deportable, and they did not qualify for that exception. So I just want to just be very careful. I'm encouraging you, when you are completing these I-9s, do not check off that box. Now, another thing that employers are utilizing is the e-verify system. The e-verify system is a computerized system where it is directly connected to the immigration system. So an employer is able to determine right away whether or not you have legal status to work. So if you know that you don't have status and the employer participates in e-verify, be very careful as to what you're doing, because now it is your information is being sent and it is sought to be verified whether or not you in fact have work authorization. So you just have to be careful in what you're doing. You don't want to block yourself from ultimately getting lawful permanent residence and thereafter moving on to citizenship if you decide to do so, right? Okay, now another thing is the e-verify system is a computerized based system that it checks also with social security. And what I'm finding is when people are adjusting their status, they are not, after they have received the green card, they're not going back to Social Security Administration and providing Social Security with a copy of their green card so Social Security can update the records. Once you change status, if you're moving from where you were previously a visitor and then you were able to get a green card, you should go to Social Security and you should update your status. So if it is that you ultimately move from a green card holder to a citizen, you need to go to Social Security, provide Social Security with your documentation that states that your status has changed. The e-verify system is in fact being connected to Social Security Administration and immigration. And oftentimes with the e-verify, it will bounce back because you failed to regularize your status as well with Social Security Administration, right? So just tuning in, welcome. You're listening to Legally Speaking with attorney Antoinette Osbourne. If you have a question this morning, you can call in at 718-502-9137. That is 718-502-9137. All right. Now, this is the issue now that we have with people working without authorization, and it is subsequently discovered. Working without authorization, where it is discovered, can permanently block you from obtaining a green card. Now, there is some exceptions to this. The general rule is if you have worked without authorization, then you are blocked from getting a green card. There is, however, an exception to the rule. And the working without authorization is not limited to after your most recent entry. Immigration looks back. So let's say you just came in July of this year and you didn't work, but prior to this, where you had come probably in 22 or 21, you worked without authorization, and this is discovered, then this working without authorization can in fact block you from obtaining a green card. However, as I stated, there are exceptions to this, and one of the main exceptions which is able to benefit a lot of people is if you fall within the category of an immediate relative. Good morning, Suzette. Good morning, Steffi. If you fall in, good morning, June. If you fall in the category of an immediate relative, then the fact that you worked without authorization is not a bar to you getting a green card. And who are the immediate relatives? Immediate relatives are spouses of US citizens. They are the children under 21 who are US citizens, and they are also the parents of US citizens. Notice the emphasis on US citizen. Notice the relationship, emphasis being placed on spouse, child under 21, or the parent of a US citizen. If you fall within this category and you worked without authorization, then it does not affect your ability to get a green card, provided, of course, you did not claim to be a US citizen. That is paramount when they are trying to decipher whether or not you can be barred. And one of the hardest things is where you finally have the ability to file for status, and then here comes a hurdle, right? And I'll never forget, a client came to me, her sister had filed for her. And I think this happened in Long Island. Her sister had filed for her, and anyone who is very much aware, back then I think it was taking siblings to sibling filing was taking 11 years. Now it's taking about 17 years. That's how long it is. And after waiting 11 years, and anyone who knows, as an immigrant, this woman was in the country for years. And at her interview, because I want you to understand that immigration does their separate checks other than the documentation that you send in. And the officer was able to determine that, and I'll tell you how innocently this happened to this woman, but then it became a permanent bar to her getting a green card. She was out, I believe, with her relative one day. And anyone who's out, especially these times, you're going to see people outside encouraging you to register to vote. But the situation was a little bit different for her. There was someone who was running for federal office, and he said to her, "Well, you've lived here for years, you have the ability to vote." And she went ahead and she registered to vote. So, come 11 years after waiting for this green card, she goes into her interview. It's her and her sister. And the officer says, because they're asking you a question, oftentimes they already have the paperwork in front of them. They know the answer. They're just waiting on your testimony. And he said to her, "Have you ever registered to vote?" And the woman, being quite truthful, she stated yes, right? She stated yes. So, as a result of which, unfortunately, he said, you qualified, but for this. And, but for this representation, I have to deny your case. And waiting 11 years. Anyone who has gone through this whole process where you have legal status, especially if you adjusted here, it's a different type of nervousness than I believe than when you're outside the country. And this woman waited for 11 years to be told no, just because of that simple registration. So you have to be very careful. Read the forms when people are putting forms before you. I want you to read those forms. I want you to ensure it does not state that you are in fact electing or claiming to be a US citizen if you are not. We don't want to have people blocked from citizenship or for people to be blocked from getting a green card where, other than this registration, you were eligible, and the woman was devastated. There's absolutely nothing I could do for her. She made the claim by registering. It was a false claim to US citizenship, and she was, in fact, permanently blocked. And it was so sad because it is a woman who sought to live her life in a very keeping on the right hand side of the law, but for this representation. And it's truly disheartening, right? So it is what it is. So someone texted, "Good morning, Miss Osborne. I filed for my unmarried kids, and their priority date is March 21st of 2018. I'm a US citizen. Do you know how long more I have to wait and what year they are at now?" All right. So unmarried kids, you are an unmarried adult kids. When I say adult, I am specifically referring to kids over 21, right? So if you're over 21 years old, you are in the first category. And in order to check which cases are being processed, you can just Google visa bulletin, you look under the family-based sponsorship, and you check the first category. Right now, they are working, and the first category is for the single children of US citizens. So, right now, they are processing October 2015, right? So basically, this tells me that you have an approximately 9-year wait, right? Or 8-year, 11 months. So in terms of your application, what I would do is I would, in filing in 2018, I would add 9 years to that. So you are looking at 2027, right? and probably March 2027 or January, February 2027. So I hope that assists you as to where you are in the processing. So, simply put, it's all a matter of calculation. But if you're just joining us this morning, we're focusing on work permits. We are, in fact, focusing on people who have worked without authorization, where it stops you from getting the green card. So, I wanted to just go over categories who are in fact exempted. So if you're just tuning in, welcome to Legally Speaking with attorney Antoinette Osbourne. This morning, the focus is on work authorization in terms of who is authorized to work, where, and in addition, if you have worked and it is discovered and you don't fall within the exceptions, that you're going to be barred from getting the green card. All right, so we just went over immediate relatives. You are an exception. If you've worked without authorization and you're seeking to adjust your status, that will not block you from getting a green card. For people who are VAWA victims, that's the Violence Against Women's Act victim, if you've worked without authorization, this does not block you. You'll see on the application, it does ask you whether or not you have worked without authorization, and it has asked for an explanation. But the fact that you have worked does not prevent you from getting a green card if you are a victim of domestic violence, filing under the VAWA provisions, right? Certain physicians, I'm just going down the list of people who are exempted if they have worked without authorization and they're now seeking to adjust their status. So, certain physicians and their spouses and children that come along in the application who will be their derivatives, certain G4 international organization employees, also NATO 6 employees and their family members. Also important is the special immigrant juvenile, right? So the special immigrant juvenile, if you've worked without authorization, then it does not affect your green card authorization. In addition, certain members of the US Armed Forces. Now, we are very much aware that starting August 19th, for people who were spouses of US citizens, right? And they were in the country for 10 years and they have been married, I believe, as of July 17th or June 17, 2024, to a US citizen, you can apply for parole. What I want to encourage for those of you who may not have had the benefit of a US citizen spouse, but you have, let's say, a child that's in the military, then you can apply for parole in place if you entered without inspection, if you weren't admitted or you weren't paroled when you came in, let's say years ago, you crossed the border, right? Because I had a lady who entered into my office, and unfortunately, she was not married, but her son was thinking about the military. And this was a way, once he gets into the military, for her to apply for parole in place. Because it's not just that your child is 21 and over and a US citizen, you still have to show proof of your entry. And one of the ways to address is either if you actually came in and you're inspected, admitted, or paroled, right? So when you're inspected, they admit you in, or some people come at the border and they are paroled in, right? So it's a question of admission or parole. So for her, she didn't qualify for this new Biden immigration parole. But her son is going into the military, and once he's in the military, she will apply for parole. So there are different avenues that are open to people to be able to apply for adjustment of status. But anyone who has absolutely no proof of admission, you know that you're going to be doing a provisional waiver. But one of the restrictions in doing this provisional waiver, you cannot adjust your status. Yeah, you have to, in fact, interview outside the country. And when you go to that interview, the officer is going to ask you, how is it that you entered? One of the main reasons is they collect this information because they want to secure the borders. So you will be asked that, and you better know how it is that you entered. All right. So those are the people who you could have worked, but it doesn't block your green card. So let's go over that again. Yeah, we have the immediate relatives, the spouses of US citizens. We have the children under 21. Yeah, and this is where adult children who are filing these adjustment applications, you are not eligible for an adjustment of status if you are over 21 years old, unless you're 245I. You have to know that you are, in fact, you have to qualify for a provisional waiver. One of the drawbacks to this waiver application is you need a qualifying relative. Yeah. The problem is not everybody have the qualifying relative for this. The qualifying relative for this provisional waiver application is a spouse who is a citizen or a green card holder, or a parent who is a citizen or a green card holder. Not everyone has this relative that causes them to qualify for an adjustment of status. Yeah? All right. Now, it's sad because you have so many people who qualify for this green card and they're not, in fact, eligible for a waiver. So they get stuck here, you know, and literal frustration because they anticipate. I know for me, I had one of my clients who, after waiting for like 8 years, she had put in her application as an adult child. The mother filed for her and she got denied, and they were shocked. And I said, by you putting in this application, I know you did not use an attorney, because no attorney in their right mind would put in and tell you that you could adjust your status, that you could pick up in the United States. Yeah. So her application was denied. She eventually got married, and it was the husband who was able to have her adjust status. Yeah. So I just want to encourage those of you where your adult children are here. I have a client, she's battling with her son right now. Yeah. And this is after we were able to overcome a requisition hurdle. But sometimes your children are unruly, and you really can't control them. So when they come here and you're filing for them and they need someone, you have to be very careful where your children come here, you're filing for them, and they need someone. If they have met someone who says they're going to adjust their status, and your child who has the ability, especially when their priority date is fast approaching, they meet someone and the person encourages them to stay. If they overstay, here's the difficulty. If it is that your child overstays and the person who encourages them to overstay decides that they're not going to continue with the application, and your child is now in a position where they are out of status, they're going to need a provisional waiver, to go back and interview where they have come on a visit, the dates are close, and my thing is, as a child, an adult child, where my parent is filing for me, if I have met someone, and especially if the relationship is new, if you want to continue with that relationship, because one of the dangerous things is where you give up sure for unsure. I have had clients where I have told them, don't let them stay on because they're going to need a waiver. You have to understand, a waiver can add a year to 4 years processing time to your application. And I know specifically, I encourage one of my clients, don't let them stay. And the child stayed. And now they're now frustrated. You have this long time that you have to wait. Worse, after waiting, you're going to need a waiver. So imagine waiting like, let's say you are the child of a US citizen and you wait that 9 years and finally the visa number is available. Now you overstay, you have to file for a waiver, and this adds possibly another year to 4 years processing time for you. Whereas if you had gone home as instructed, you would just be preparing, instead of waiting an additional 4 years, you'd be preparing for your interview at the embassy. And I specifically said to my client, you see, because right now, the person showing signs, it was a rush before. But you see, what people don't understand, live and see. When you come live with somebody and see a two different something. When you're dating and you're not living with a person, you are able to, continue with certain things. When you start live with a person, them really start show you them true colors. And oftentimes when you come live with them change their mind. Them know why you again. So you just have to encourage your children concerning the decisions that they are making. Because you go ahead, you pick up a piece of crosses. No, sir. Just be very, very careful. We have to encourage the children. Everybody wants their own way, right? But it's going to end up costing more. Because here's the thing. Once you get married, in a different category. You better have not been married if your parent who filed for you was a green card holder. Can you just kill that application? So let me show you how things can really go down south, right? Your parent has filed for you, but you come meet some crosses girl here. You decide you're going to marry this person. You marry this person, and this person decides they're going to change their mind. They're not going to follow through with the application. So you just put yourself, right, in a category where you waited 9 years. You are now going to be waiting, let me see, for married children. Married children is now taking 14 years and approximately 5 months. So you engaged in all of this. You pick up crosses, I know you're stuck. The person decided they're not gonna file for you again. You are completely out of status. And you just be very careful. I want, especially your priority date is approaching. If you have the option, I'll tell anybody, if you have the option for anybody else than a spouse to file for you and you're close to your priority date, I would not encourage that person to stay. The reason being is if that marriage isn't believed, or if your spouse decides to change their mind and juke you, you're stuck. Yeah? But it is what it is. People do their own thing. I You can only bring the horse to the water. You can never force that horse to drink. So people will do what they want to do. It is what it is, And right now, what can you do? If you tell your child this is not the way your application is being processed, and then they decide to take it on their hand that they are going to in fact do what they want to do. It is what it is. All right, so bear with me 1 second. I'm trying to. All right. I wanted to be able to see. All right, so good morning, Christopher. Good morning, Trevor. Good morning, Renat. All right, so Renat says, of the books, domestic work was the immigrant survival back in the day, right? So they're moving past that now, Renat, right? So Christopher Henry says, good morning, Miss Osbourne. I filed for my son. He came up on Friday. His grandma wants to take him on a cruise in September with the family. Is there a problem for him to travel and come back to America? All right, so if it is that he has not received the green card as yet, because he has gotten a I-551 stamp in the passport, if the cruise is within the dates of the stamp, because immigration just want to ensure that you've entered. So if the cruise will cause him to come back before the expiration date on the I-551 stamp, then your son is fine, right? Just make sure he has already entered. So make sure you've also paid that fee for him to be able to get the green card, right? Now, Pauline has asked, Miss Osborne, when a child is filing for a parent and the parent decides to come up and overstay, how will that affect the filing process? Well, that parent who is here can file for an adjustment of status, but you would wait 90 days before putting in that application for an adjustment of status. Remember, preconceived intent is always going to be on the officer's mind. If it is that you step out of the prior to Trump, it was like a 60-day period. Trump extended it to a 90-day period. So you have to wait 90 days, right? And once you are, in fact, outside of that 90-day period, then the preconceived intent is basically out the door. Good morning, Michelle. All right. Now, we want to look at people who they're authorized to work without applying for a work permit, right? If you're a green card holder, you don't need a work permit. Imagine I had to be arguing with a client, her work permit was up, but then she got her green card. She wants to renew the work permit. You have to understand your green card puts you on a higher level than a work permit. If you have the green card, that is proof of your ability to work and live in the United States permanently. You are also authorized to travel without seeking any additional documentation from immigration, right? All right, so let's look at people who are authorized to work because of their status. If you are a green card holder, you are in fact authorized to work without applying for a work permit. Your green card serves as your work authorization. For those of you who have thanked the live, thank you so much. Don't forget to like the live. Don't forget to share. Don't forget to subscribe. All right. Now, if you have lawful temporary resident status, then yes, you don't need to apply for a work permit. So now we're just going over the list of people who you don't need to apply for a work permit. If you've been admitted as a refugee, you do not need to apply. You're authorized to work because of your status, right? So we have the green card holder, we have the lawful temporary resident, we have the refugees so far. So now we just want to go over the list where just by your status, you are in fact authorized to work. People who have been granted an asylum, right? People who they're admitted as a fiancé. The difficulty is you have to marry. If you bring a fiance here, yeah, you have to marry within 90 days. Now, if you have failed to marry your US citizen within that 90-day period, you're just going to have to file an adjustment of status based on the relative petition. So don't think that the fact that you did not marry within 90 days, you're doomed. But the drawback with the fiance visa is you better be marrying that fiance. No one can accord you that green card here to adjust status. So people who unfortunately came, it didn't work out with the fiance. I remember years ago, a man had called into the show and he had said that his sister came, and when she came, because I tell you, come live with me and see, it's two different things. When she came to live with the gentleman, it turned out to be a complete nightmare. And she decided she had a better life back in our home country. She's not going to stay. Not everybody is going to, because some people back in their home country live better lives than they do here. And she decided she was not going to put up with it. So she left. Yeah. I mean, people who they're living their lives, they're very comfortable back in their home country. A lot of people are not going to come here to get abused just because of what we refer to as the almighty dollar, right? They will go back home. Yeah. And that's what she did. All right. Sad how relationships sometimes they're not working out and people's lifestyle are in fact changing. No one is really focused on family anymore. But don't forget to join us at 11 for Fumi's Village on Future FM at 11 o'clock. You can listen in online at futurefm.net and join the conversation. You're more than welcome to call in. And as we discuss the importance of, and my focus is on the traditional family, the nuclear family. My conversation does not extend past that. All right. So fiancés, people who have been admitted as a non-immigrant pursuant to the Compact of Free Association between the United States and the federal states of Micronesia. I don't even know where that place is on a map, right? For people who have been granted withholding of deportation or removal, because sometimes you may put in your application where you are seeking to cancel your deportation, and possibly the judge doesn't feel that you qualify for an asylum, but she does believe that you will suffer some harm if you go back home. There's a risk to you going back home. So what they do is they grant withholding of deportation. Then you have the deferred enforced departure, people who are accorded that status. You are allowed to work. Anyone who's been granted temporary protected status, the only island that really has benefited from that from our region is Haiti. As anyone, I think they recently got a new president, but like Haiti is in a state of disrepair, and we have to pray for our brothers and sisters from Haiti. Like, you could just be walking and just get kidnapped. Yeah, like you're anywhere close to Port-au-Prince, it's a disaster. All right. If you have been granted voluntary departure under the Family Unity Program, you are also allowed, that's evidence of your work authorization. Anyone has who has been granted family unity benefits. So you have quite a list where just by your status, you're authorized to work. You have the V non-immigrant status once it has been approved. Same for the T1s. This is trafficked victims. And with all the allegations going out right now in the entertainment industry, allegedly, that they are girls who are applying to, and I think from years ago, we were very much aware a guy come up to you and say, oh, he can get you into modeling. That's for people who are actually interested in that sort of lifestyle. You were one to be very careful because this is a way all of a sudden these girls end up in the porn industry. They end up being shipped out. You have to warn your children as well. Yeah, if it looks too good to be true, probably it isn't true. Yeah, and I find people are very gullible, and you have to protect your elderly parents. And who often stops this nonsense with the scamming is people at the bank. Because when I see these elderly people coming in, and here it is, they are in fact sending monies out, especially overseas. Yeah, they're sending monies out overseas. They don't even know the people. The banks now play a vital role in nipping this nonsense. But it's sad that we have so many young people who are being trafficked. And this is where, as parents, you have to get involved in your children's lives. Yeah, you think that everything is fine. You're providing a roof over their head, you're feeding them, you're clothing them. Yet these children nowadays, they're existing in a completely different world. A lot of them, they're confused. They don't know who they are. They don't know their sexual orientation. I think the first educational institution your child should encounter is your home. That's your responsibility. It is not the government to teach your child how to be a responsible human being. Yeah? All right. People who are crime victims. If you have been accorded a U visa, not sure. If you've been accorded a U visa, right? Your U visa has been approved. You have the ability. That's your ability to work, right? So, just tuning in, thank you for joining us this morning. We wanted to focus concerning work authorization, and we went over the exemptions as to people who have worked without authorization. You still do qualify to get an adjustment of status. We want people to get green cards. We want to encourage them because, of course, once they are able to get stability here in the United States, it is a support system. They bring their families. I'm not talking about the scamming people who are legitimately working to bring that family unit together. Yeah. One of the things I want to encourage us as a people, though, is do not create a false expectation, right? And when I say a false expectation, I'll tell you what happened to one of my clients from Haiti. Anytime her husband went down, right? He, in fact, would be spending all his monies presenting a lifestyle he did not live here in the United States. The most expensive clothes bring her the most expensive things. So she thought he was living this grand life here in the United States. When she came, he lived in a basement. There's nothing wrong in living in a basement, right? I myself have lived in a basement before. There's nothing wrong with that. But you going down, you're presenting and you're creating an expectation that is not going to be your spouse's reality when you come. And every place that they live, because the man was so horrible, I can't describe him any other way. The man was so horrible. They go somewhere, they live 2 months, they're kicking them out, right? Landlord running them. Absolutely disgusting man. Even so, till in trying to divorce him, he tried to make her life a living hell. Yeah? But thank God the judge saw right through it. We're able to get the divorce. And for people who think you can force people to remain married to you, I'm going to tell you it doesn't work out like that. You cannot force someone to remain married to you, especially in New York. All you have to, I think the only people who probably suffer like that is people in the Philippines, because I understand it's hard to get a divorce there. But if you are married, and I can't understand, just work out the financials. You're going to try and force someone to stay married to you. Why? Why would you do that? You're telling me this place has over 1 billion people, you can't find somebody else? Makes no sense. All right. So thank you so much for tuning in. Enjoy your Sunday. Take care.